Hi, good afternoon. I'm attorney Rachel Cheek, and joining me today is attorney Shannon Brewer, both from Hill and Ponton, here to answer some questions. How are you doing today, Shannon?
I'm good, Rachel. How are you?
Pretty good. Enjoying the fan that's just out of frame blowing on me from this Florida weather.
All right, so we'll just get started. Throw that first question up there.
All right. Mila M says they're filing a new claim to get from 70% to 100% for PTSD. I have an intent to file dated for next month. What's the correct form to use? I keep getting different answers. My psychiatrist thinks I should be at 100% and did a DBQ showing that. Is there anything else vital for him to list on the DBQ? Okay, so we kind of got two questions here.
Three.
Is there any other vital advice to give concerning going from 70 to 100% for PTSD, even if awarded 70% last year? Okay. 3 questions. I'd say 2 and 3 are a little similar. Basically, what do you need to show 100%? And then, of course, the first question is, what's the right form to file? Which is a good question to ask because VA gets very specific about those. In my experience, well, actually, it depends, I guess. If you were granted 70% last year and you're still within the appeal period, meaning it's been less than a year since your decision, it's dated after June 2024, I would suggest filing an appeal to preserve the earliest effective date and asking for a higher initial rating of 70%. Now, if you're not within that year timeline, it's going to depend if you have filed for higher rating before. Shannon, do you see a lot of those requests for supplemental forms or requests for 526 initial claims? Basically, whenever you filed for an increased rating for a condition that's already service connected, I get that all the time.
So I always file claims for increase on a 526, a new form. It doesn't, we have found at the VA that it doesn't matter what form you file, you're probably going to get a letter saying it's the wrong form. That happens a lot. I file increased rating on a 526 unless, as you said, if it's within the year, I would go ahead and file a supplemental appeal instead, or, with your new evidence from your doctor. So I would file it as a new claim 526 if it is in fact past the year. But if you're trying to go back and you're still within the year, then the supplemental appeal is how I would file it too.
Definitely. And what about going from 70% to 100%? Basically, what information should a veteran include if they're looking to get that disability increase?
So from 70 to 100 is a big jump. And so under the current rating schedule, the way it's written right now, it's really hard to get to 100. Generally, most of my veterans don't meet that criteria. So if you're kind of functioning in your life and you're not totally occupationally impaired and totally socially impaired, you don't meet the 100% criteria. But if you do meet them, you're looking for things like delusions, persistent delusions, being a persistent danger to yourself or other people, not being able to keep up with your hygiene, not, and sometimes kind of losing where you are and what's going on. You're kind of starting to lose a little bit of touch of reality. So it's a pretty high standard right now. We are hopeful that they're going to make changes to that to make it easier to get to 100%. But right now, that's kind of where we are.
Yeah, that's a great point. 100% for mental health is a very high bar to reach. People do it. I definitely have seen it. But another thing I would emphasize is examples. So your doctor's completing your DBQ, so they're going to be, checking off some of those symptoms. I think really giving examples is some of the best ways that you can get new evidence in front of the VA, whether that be your psychiatrist writing down things that they know have happened or a statement from yourself. So for example, grossly inappropriate behavior is a 100% standard. That's extremely open to interpretation. But I've seen things like, a veteran having to wait for a medical appointment understandably that's irritating, but just getting to the point where they blow up and yell and cuss at the nurse and have to be escorted out. Or veterans who I've talked to, one's family was like, he just started cracking up at a funeral. It was really inappropriate. This was a sad, like, quiet occasion, and this is completely inappropriate for the situation. So things like that, I definitely would encourage you to get specific, not just, yes, this, you have the symptom, talk about how you experience those symptoms and how they manifest.
And also consider unemployability. You know, if you meet the 100% criteria and you're totally occupationally impaired, then another way to possibly get there is to fill out a VA form 8940, explaining that you can't work and that you're not working. And that's another way to possibly get to 100%. Okay, this question's from Cincy Rebel. Looks like this is part 2 of a question. Do we have part 1? Let's see. I'll just start with this. Put into my medical records that the DDD is degenerative disc disease is likely due to my altered gait and biometrics from the pes planus. Worth an HLR. Should I convince my VA doctors to write me a nexus, pay for a nexus if not? I'm going to need part 1 of that question in order to know the answer to that. What I can say is that if you have medical records that you're wanting to submit, then you're not going to want to file an HLR. You're going to want to file a supplemental claim appeal because you cannot submit new evidence with an HLR. But without more of that question, that's the best I can do to answer it. You have any other ideas, Rachel? Am I missing anything there?
I'm just the same as you, trying to interpret from the information that we have. I would say yes. If that's new medical records showing that your back is due to your altered gait, you need to do a supplemental. But if it's already in your file, then yeah, an HLR is worth it. Why not try it out? Point out where it is in your file and when it was received by VA or when you submitted it. And then, so I always say try the HLR, see what happens. And then, yeah, if it's not proven and your back is a significant disability, absolutely need to pursue a nexus letter if it does get denied, because that is a very common cause. Altered gait can absolutely lead to problems further up the body, including the back. But without more information, we can't really get more specific than that. However, if that's the cause, I would definitely encourage you to continue to pursue it, whether that be through a paid nexus letter or if your provider is willing to note that. You can also submit medical literature supplemental. Okay. Oh, this is a good question. Annette Baker asks, when do the 0 percentages, I have 3, count as 10%? I have 70% for MST, PTSD, 50% for migraine, 10% for tinnitus, 30% for heart, and 30% for skin. It comes to 94%. Why not 95%? Getting me to 100%. That is a really good question. And the 0% is rhinitis, burns, and FSAD, female sexual arousal disorder. I can tell you right off for that one, it's always a 0% because they will pay special monthly compensation for FSAD or for men ED. Burns, for scarring, they almost always are going to give 0%. But if you have, if your burns are painful or unstable, meaning like the skin covering comes off of them, or they weep or bleed, or they just don't stay closed, you should have an additional rating for that. Or if you have pain from the burn scars. Rhinitis is going to depend on your symptoms. I understand that's not really the question that you asked, but I'm just looking at this. I'm always trying to get up, with that additional 10% for the rhinitis or burns could help. But as I believe what Annette's asking here, there is some rule where multiple non-compensable or 0% rated disabilities can be combined to reach a 10% rating. I have not actually seen that in practice. I'm familiar, or I understand the rule. Can you tell me any more about that, Shannon?
My understanding is that only kicks in if you don't have any rateable conditions. So if you have all 0% and you have 3 or 4 zeros, then they're going to give you a 10 for that. But if you have 70% for PTSD and 50 for migraines and you have compensable ratings already, then that's kind of a rule for people that have disabilities that don't get any compensation to allow them to get some. My understanding, though, is that only kicks in if you're not getting paid otherwise.
And that makes sense.
So yeah, I would go with like what Rachel said, and try to maybe look at your burns and see if or your rhinitis and see if there's a way to go up there, or secondary conditions. Always look for those.
Again, back to individual unemployability, based off I know a lot of times with mental health alone, if you're at 70% or higher, that's really going to make it difficult to work. Hell, if you're less than that, it can be difficult to work, but certainly when the VA acknowledges it's 70%. So another thing you could do to get that total compensation is ask for individual unemployability. And I would ask for it specifically due to your mental health, if that would, does in fact lead you to not being able to work. Because if you get it based on individual unemployability based on one condition, your other conditions can come into play and bump up your monthly payments. But yeah, think about the burns as far as painful and instability, and also rhinitis. I believe a higher rating is going to be based on what percentage of your nasal passages are blocked, I believe. So yeah, check those out and see about getting higher, and look into individual unemployability if you're not working, and that would apply.
Okay, this question's from Pot Scraper. Do I need a DBQ for a Gulf War presumptive claim, even if I have a nexus letter, the correct location and correct time all in place, and a current diagnosis, or will they provide one at the CMP exam? They will provide one at the CMP exam. I would say give them the chance to try it first. CMP exams aren't always great, but we see favorable ones. And if it's a presumptive condition, it's harder to mess that up. So, make sure that my main concern would be if they get the rating correct. So just kind of be aware that even if they don't, if you get it granted or you don't, or they grant it and give the wrong rating, you can always go back in with your new evidence. You can appeal that and get your rating corrected or get it service connected. But I'd give them the chance to do it right first.
Yeah.
Or get a copy of the report and then decide if you want to get a DBQ.
Yes, I agree. I always see what evidence the VA gets, because if it's negative, you're going to want your evidence to address whatever VA said
exactly
was the reason they didn't grant. Okay, Laura Bradford says, hi, thanks for what you do. Part 1, my supplemental claim was abruptly closed on June 3rd after being under review for 6 months. Open to active correspondence the next day only, allowing evidence uploading. But if they don't allow backdate to original, I lose my 1-year appeal status and continuity of pursuit. Have you seen others like this? Sent original and new 0995 plus all documentation. Can we pop back to the first question, please? All right. Okay. Yeah, actually, we see this all the time. VA loves to close out claims. They love to say, we found an error. We'll get back to you. Just close them out. They love to say, okay, here's a decision on some stuff. We're deferring. We're not going to give a decision on these other issues, but we'll get you one in the future. Closed out. It's so common. So when that happens, because it unfortunately is frequent, and the claim has been closed without giving you a decision and without giving you a reason why it was closed. For example, a letter saying, we were talking about earlier, you filed the wrong form. We can't process this claim. Or, you filed a supplemental claim, but you should have filed a 526. If they're just closing it, again, we see that all the time. I don't know, it's people clicking buttons or something. What I would do is let the VA know, either through calling their main office or sending in a 4138 form, and just say, hey, I had my supplemental claim was pending. It was closed on this date. I haven't gotten a decision on these issues. Can you please look into this and make sure that claim is reinstated? We have luck with that. I don't know if it's because it comes from an attorney's office, but I think a lot of times that mistake gets made at the VA. They don't even notice. It's not malicious. It's negligent.
Sure, it's not malicious. Okay.
Yeah.
I don't know that I agree with that. No, I do agree with you. And we see it all the time. Things are closed for no apparent reason. We email everybody at the VA and send letters and call and just reach out to everybody that you can and say, you've closed this inappropriately. Please reopen it. Please explain to me why it was closed, something. Worst case scenario, if I can't get anybody to do that, I will refile the claim with a cover letter with the claim saying, I am preserving my effective date here. I filed this already. I am filing this in an abundance of caution because you will not answer me and you will not reopen my claim, but I still want my effective date. And then if they don't give it to you, you can appeal for your effective date. So your main thing is you want to get them working on it again. So if you can't get them to reopen that one, file a new one with a letter stating that the reason you are filing it is because they will not appropriately adjudicate the claim you already filed. So just kind of, leave a paper trail.
Yes. And it sounds, at least, Laura, it sounds good. It sounds like you did that. You said she filed the initial one and a new one, like, here you go, here's all the evidence. But yes, you just get it on the record. That's why I suggest call the VA. They have to put those calls in your file because a lot of times those claims get closed and that's the only record. They're not being closed with a decision attached. So if no one follows up on it or asks about it, it's not in the system. So just when you do notice that, make sure you bring it to their attention.
Absolutely. Okay, this question's from Lonnie Brinson. Is it pyramiding if I am rated SMCL for loss of use of both feet and 30% for ankle fusion since it's part of the same anatomy of the body? If so, do I notify the VA and say they got it wrong? I'm not sure what the question is so if they've rated you for loss of use and they've rated you 30% for ankle fusion, and then they gave you SMC on top of that for loss of use of both feet, that's not pyramiding. If you're saying they won't rate you for loss of use of both feet for some reason, saying that
it sounds to me, and I could be getting this wrong, but it sounds like he has the SMCL rating for loss of use of both feet, as well as a 30% rating for his ankle fusion. Mm-hmm. That the VA assigned both of those, and you're asking if that is incorrect, is what that's sounding like to me. But
so you're wanting to notify them that they made a mistake and gave you something you shouldn't be getting?
Yeah, please let us know, Lonnie. We want to answer this.
I generally would let them figure it out. I mean, if they say it's not pyramiding and they granted it, then it's not pyramiding and it's not your fault. If they do later catch it and say that it is, then they're probably going to say there's an overpayment, but that would be their error, not yours. So you shouldn't have to pay that back. But my only question is the loss of use of both feet due to the ankle fusion? Because if that's the case, then you might not be supposed to get the loss of use rating and the 30% rating, but that doesn't keep you from getting special monthly compensation L, aid and attendance. So you could still have that.
For loss of use.
Yeah, I don't think it's going to be a problem.
Yeah. Also, all that as well, if you've got SMCL, the 30% rating is not even factored. You're not getting paid for that 30% rating.
Right.
You're getting SMCL is bigger than 100%. So it doesn't even sound like you would be getting anything out of it that they would even need to have a payback. But I agree with Shannon. That's for them to catch. But yes, I agree with you. The loss of use has to be due to something other than the ankle fusion, or they should probably not have that 30% rating continued. But there wouldn't be an overpayment, I wouldn't think. Happiness asks, do you guys represent veterans for both VA and Social Security disability? I'll tell you right now, we do not. We used to, but now we're only focused on VA disability law. If the caregiving spouse is on Social Security disability, does the program require a backup caregiver just in case the caregiver got sicker? Do you also help with caregiver program and disabled child? Okay. Caregiver, yes, we do assist with those appeals. Can you go to the first question, please? All right. So no Social Security. Yes, we represent for caregiver claims. I don't know. Do you do caregiver claims, Shannon? I know it's kind of some people do, some people don't.
I don't do many of them. I have done a couple.
Mhm.
But we do, yeah, and helpless child, yes, we do work on those for the dependents.
Yes. And it also, as far as your question regarding the backup caregiver, I believe you can. I don't know that one is designated. I don't think they'd be designated just because they're on disability, because it may be for reasons that don't impact their ability to take care of the veteran. But if they're very ill, I would suggest you can name a backup caregiver when you're going through that application process. So I would go ahead and get them on paper just so there's no issue in the future if the initial caregiver does get ill and no longer able to do that.
Next question.
Oh, Laura. All right.
Another question, Laura. Let's see. Part 3. Case involves new and relevant, not previously considered medical files by judge's own statement. Involved DD Form 2697 as an informal claim prior to 24 March 2015. Have found one other non-precedent. How hard is it to get this form recognized for other vets as precedential? Have you seen these claims frequently? Thank you for your time and assistance to all veterans. Go back one more to part 3 again.
And she had the question about the getting the mental health rating up, or she needed to file the supplemental claim and wasn't sure which to use. Can we pop any chance you can pop Laura's 1 and 2 up? Okay. The supplemental claim was closed. Gotcha.
Okay, yeah.
And she filed the new claim, or as well as the original or the initial supplemental appeal. Okay,
let's hit part 3 again. All right. New and relevant, not previously considered medical files. Okay, next part. I don't know what form we're trying to recognize. Is it the informal claim form? Is that what you're saying? Let's see. Form recognized for other vets as precedential. So generally, nothing is precedential with the VA unless it's a Court of Appeals for Veterans Claims case or a federal circuit case that that applies as far as the law. But because every case is based on the fact of the veteran's file and their specific disabilities, you're not going to be able to use a form from someone else as precedential, if that's what you're asking. And no, I have not seen those forms frequently. Are you seeing a different question there, Rachel?
No, I'm following you. I think our answers to the initial one still stands, like get on record, get your supplemental claim restarted. But without actually seeing the form or the specific facts of the case, I can't really answer anything more clear. Okay. DD 2697 is a medical assessment form used in CMP exams. All right. I can't say that off the top of my head I have seen that.
No.
Always worth a shot. So what if it's not precedential? It could be the facts are based on your case, and in your case, this might be what's needed.
It's never wrong to give the VA more information. I mean, things may or may not work. They may or may not apply them to your case, but I would always give them the information if you have it and see if they'll accept it.
Definitely.
Okay. Is it my turn or is it your turn? I've lost track.
No, I'll go ahead. HL asks, my migraine VA claim was denied secondary to my PTSD, tinnitus, and asthma VA disability. What's the best option, higher level or supplemental appeal? Well, that depends on what VA's reasoning for denying was. So if they did specifically say it is not secondary to PTSD, tinnitus, or asthma, okay, that lets you know they've considered secondary service connection. But is there any chance that your headaches are related to, did they come directly from service? Did you start having them during service? Or could they be related to chemical exposure? Did they consider those options? If you know for sure, like it's my PTSD. I get migraine, like they aggravate it. I only get migraines, my PTSD happens. Well, in that case, I would do a supplemental appeal with some medical evidence showing the link between PTSD and headaches. I always want to make sure that the VA has considered all theories of service connection. Sounds fancy, but just literally, have they looked at secondary? Have they looked at direct? Have they looked at exposure? If you already have any medical information and medical nexus on file that supports secondary service connection, higher level review. Just if they already have the information, point out where it is, let them know why you disagree. But if they've considered these theories of service connection and just said, no medical evidence supports a link, I can tell you right now, I know medical evidence supports PTSD and tinnitus at least being linked to headaches. I've seen that. So that would be the supplemental appeal route to give them that medical evidence. Shannon, what do you think?
I agree with you. I mean, it really depends what evidence is in your file. If you've got everything in there to win already, a higher level review, if you need a medical nexus or you need more medical evidence, or you have more to say about your condition and you want to write a statement of your own explaining, when my PTSD is bad, my headaches are worse, then you want the supplemental. It's really down to whether you need to submit new evidence or not as to which one you choose. Mickadoodle, hello, I did it, T. I received SMCM last week, the BVA granted. RO must determine effective date. Do you have to be 100% to get SMCM? I am 100%, but can they apply earlier for SMCM? Great job. Those higher levels of SMC are, that's super complicated. And the fact that you did that is great. Good job. As far, I really feel like I need more information there to know when and what, like when it really depends on what you had connected when as to when the SMCM can apply. And you also want to, I don't know what all's open right now. If SMCM is the only thing that is appealable, maybe you can't go back for an earlier effective date. But if you've got some of those issues that got you SMCM, if they're still part of this procedure and they're still appealable, you can appeal earlier effective date on those. And then, SMCM will go right back with it, because special monthly compensation, it can be just a part of getting the right rating. So I'm trying to think, and M, I almost never see M. And so I'm kind of trying to remember what goes into that. And it's like, whether you have to have 100 or not, I would think you do. I think you're going to have 100 for that, but maybe I'm wrong. I'd like to be wrong.
If I can pop, I'm always trying to get more into SMC. It interests me for some reason. I find it very interesting. It kind of seems like the only levels at which veterans actually get the compensation they should be having. Now, obviously, you can get to SMC higher levels, all different combinations. Off the top of my head, you can get to SMCM for loss of use of both hands. And then, yes, there's some other combinations. If you were granted that for loss of use of both hands, that by itself is going to be rated 100%. So I think that goes hand in hand, so to speak. Now, you could also be at SMCM because you have SMCL or aid in attendance. And on top of that, you have additional highly rated conditions. That can bump you up to SMC levels. 100% rating would bump you up from SMCL to SMCM. Also, 250% ratings that are not considered in your aid in attendance could also get you there. So without knowing for sure what you're service connected for and where the SMCM came from, I don't know that we can really help that much more. I think you would need to be 100% combined. I don't think it's specifically a rule, but it would be extremely difficult to qualify for SMCM at the level where you're combining disabilities to not have at least a combined rating of 100%. I could see some 70s thrown in there, maybe no single 100%, but generally speaking, they would be so severe as to at least combine to that. And agree with Shannon, it just really depends on what is pending. How long have any other of these claims been going back? Okay, I think that's my turn.
I think so.
Okay. Ajo asks, have you seen any claims where FSAD, female sexual arousal disorder, was service-connected, secondary to any service-connected mental health disorder, not just PTSD? Heard they will only service connect FSAD secondary to PTSD. Thoughts? Yes. First, let me answer that one. Yes, I have seen claims where it's connected to mental health, not just PTSD, depression, anxiety, any other number, bipolar, any other number of mental disorders, and medications for them can absolutely cause sexual arousal disorder. I could see VA like maybe doing it like automatically if people are rated for MST, PTSD caused by military sexual trauma. I could see that. Maybe they'd automatically do it, but it's not limited to the PTSD diagnosis. Okay. And then toxic exposure question. I was at Fort McClellan for 1 year from 98 to 99, K2 and Afghanistan, 2001, 2002. I have IBS, female gyno problems, multiple chemical sensitivities, and chronic fatigue. Advice, I think it continues. Filing for toxic exposure. I heard it's hard to get service connected. She is service connected for sinusitis at 0%. Related, it could be. You should, your rating sheet should say what caused, what the sinusitis is related to. Meeting with VA PCP, first time soon, not much documented. Recently talked to the VA toxic exposure nurse. On the phone, noted my exposures and charts. I stopped going to VHA shortly after I got out 20 years ago due to the first claims not going well. To know what I was doing, no one does on their first claims. Thanks for all you do. Okay, so let's go to number 2. I think that's where we kind of start. And then first, let me say, just because you hadn't been to VA for several decades until coming back now, that doesn't bar you from being service connected. So might be harder to get those medical records from the years you weren't going to the VA, but that won't preclude you. So she's got IBS, the gyno problems, chemical sensitivities, and chronic fatigue. And K2 in Afghanistan and Fort McClellan. So I'll say right now, the Southwest Asia deployment, you're going to have, I would hinge your claims on that.
Yes.
Fort McClellan is pretty difficult. You have to actually prove, I believe, that you were in certain areas on the base exposed to specific places. Is that correct, Shannon?
Fort McClellan's a mystery to everybody, but yeah, it's kind of based on herbicide exposure or the chemical school at Fort McClellan. So it really depends on what specifically you were exposed to, and whether you were if you were enrolled in the chemical school, it's going to be different than if you were just stationed there doing like a different kind of training. So it does depend, but I agree. This IBS is a presumptive for Southwest Asia, like you said. Chronic fatigue syndrome, if it is diagnosed, is a presumptive for the Southwest Asia as well. So, and the chemical sensitivity, yeah, I agree that I would hinge that on the Southwest Asia.
Unless you have specific chemical exposure that you can show due to your job in service, additionally to the Southwest Asia service. But yeah, you're doing the right thing. You're getting checked out. You're going to get these symptoms and disabilities documented. That's really all you can do. My advice would be to file a claim. Make sure that you go ahead and get it started now. And for anyone who's thinking about filing a claim, even if you're not 100% sure or 100% ready to file the claim, the intent to file that VA provides is really important. And that form, I believe someone mentioned it, we were discussing earlier, someone talked about an intent to file. And that form's a placeholder that tells the VA, hey, what it sounds like, I intend to file a claim. I'm not filing it yet. This isn't formal. I'm not even sure what I'm going to file it for, but I'm going to do it in the next year. So hold this spot. And then when you do file your formal claim, as long as it's within a year, you get that earlier effective date of the intent to file form. You may be way ahead of me, Ajo. You may have already gotten that all done, taken care of. But if you haven't, definitely submit an intent to file. That's something that, these conditions, like Shannon said, many of these are presumptive. So you're going to get service connected. It's just a matter of when. Go ahead and preserve the earliest effective date for yourself. Anything else?
Okay, this one is from Isidoro Vasquez. Hello, I found out during my CMP exam that my blood pressure medication is for hypertension. I currently have 10% tinnitus and tried to get a secondary for insomnia, but I got a 0%. Can I submit another secondary claim for hypertension for my tinnitus because of my insomnia? I did have my primary care at the VA that my insomnia is related to my tinnitus. Thank you. Yes. Always yes. If your doctor says it's related, then it is. So with the insomnia, I'm surprised they gave you a 0. That a 0% generally means that your condition is completely controlled, that you're not having any problems at all. And if they diagnosed you with it, I doubt that. I doubt that it's completely controlled because you're clearly having problems sleeping. So I would appeal the rating on that, just saying, first step. As far as hypertension due to tinnitus, I don't know, but hypertension due to the insomnia, I could see that. You want a medical opinion on it, though. I'm going to be honest with you. If you just go into the VA and file the claim for that, their CMP examiner is going to say nope. They're just not going to do it on their own because they don't jump through the hoops on their own. You have to do that for them. So I would say definitely get your doctor to write that down. If they don't want to write a letter for you, at least get them to put it in your medical records. That's good enough that those conditions are related. And yes, I would file that. Would you, Rachel?
Absolutely. Could we see the first question again? I just want to make sure. I believe CMP exam. Okay. All right. So another thing too, I totally agree, Shannon. You're going to want to get a medical opinion. If you want to keep the claim alive, so to speak. When they denied you service connection for hypertension, were you already service connected for insomnia? Even if it's rated to 0%, if you've been service connected for insomnia since hypertension was denied, yeah, you can raise that as a new issue, as a new theory of service connection. I'm claiming hypertension. Previously, I said it was due to tinnitus, but I do believe it's due to my insomnia. You can do that, but what that probably will do is just, lead to another VA regional office denial saying there's no medical evidence showing a relationship. And what you need to do is hit them with that nexus letter or medical research pointing out, yes, in fact, there is a lot of medical literature. The search the CMP examiner performed must have not been quite adequate.
I'm shocked.
Who would have thought it?
Okay, got another question from Ijo. Any updates on new mental health changes happening this August or delayed? Need to claim mental health first time. Not sure if I should wait to get DBQ and Nexus from private provider. Don't provide VA or third party. Don't trust VA or third party. If change will go into effect, which means new DBQ. Any thoughts on new mental health changes, positive or negative for veterans? Thanks again. Okay, don't wait. Go ahead and file it. It doesn't matter if if they change the law, you get the benefit of whichever law is more beneficial to you. If you file it now and the new regulations are better for you, you still get those. But you're losing your effective date by holding on to it. So file it now. As far as which ones are going to be more beneficial, supposedly they are doing this to make it easier for people to get to 100%. I am an eternal skeptic. I'm going to see what they do with it first. And as far as, how they apply it, it looks okay. It looks unnecessarily complicated, but it looks okay. I can't see that it's going to hurt any veterans yet, but we'll see what they do with it. That's where it comes down to it. I sound very cynical, but I want to see how it's applied. So we don't know yet. And as far as August, it's been several years now that we've been being told it was coming out. I don't think August is firm. I'm not sure. I mean, I think that's what they're aiming for, but I'm not sure that's a firm date yet. They were also aiming for last February, so we didn't hit that. But don't hold on to your claim. Go ahead and file it. I absolutely get it in.
100% agree. Anchorage Prepper has a question regarding had a claim for Crohn's disease. Just found out on my C-file the rater questioned, are my perianal cysts related to my Crohn's? The examiner forgot to address this in the CMP. Is this DTA or duty to assist error? Yeah, I think so. I would certainly raise that to the VA and note it's literally like it was raised here. It was either an actual question posed to the examiner or the rater noted this in the rating decision or somewhere in the file. But no development was ever done. You know, yes, you have Crohn's, but you also have the cysts. And if they're secondary to the Crohn's, they should be service connected. Any complication or residual of how am I trying to say this? Of an underlying disease. So say the underlying disease is Crohn's. Any noted complication, side effects, anything that's noted in your file to be secondary to that, you should be service connected for on a secondary basis as residuals. So I would point that out. Shannon, any additions?
I agree. So basically, the VA asks the CMP examiner questions. If the examiner does not answer those questions, that exam report is not adequate for rating purposes. That's kind of, there's case law on this. That's well accepted. It's not good enough. Now, if you've waited or you didn't know about that and it's been more than a year, you're not going to be able to go back and get that. Because a duty to assist error is not Q. It is not clear and unmistakable error. So you cannot reopen that old claim based on error and get that earlier effective date. But if you're still within your year, absolutely appeal. And if you're not still within your year, still open it, but just know that you're not going to get to go back and get that earlier effective date at this point. Okay, this question's from Natalie W. When I got out in 94, I was rated for rhinitis sinusitis. Now it just shows rhinitis. Would I file a supplemental to get sinusitis again? That's odd that it just jumped off.
The rating criteria changed?
I guess, yeah, they did. But I'm surprised they didn't just, I mean, they should have told you they were doing that, you know, if they changed something like that. I'm assuming, though, if it was rhinitis sinusitis as one condition that they were rating, and it didn't change your rating, I guess they don't necessarily have to propose to reduce if it didn't change anything. Yeah, if it didn't hurt your rating, there may not be an advantage to you to filing it and reopening it, but you would file a supplemental to get it opened up again. Yes.
Mm-hmm. Yeah, I would wonder if it maybe has something to do with like at the time you're rated in 94, I'd have to look at the criteria. Maybe they rated those two conditions together or you couldn't get a separate rating for each one. Now, however, you can. So even if it didn't change your rating when they took it off, depending on what your symptoms are for sinusitis and rhinitis, you could be getting two separate ratings. So I would, make sure that you get your episodes of sinusitis documented and on the record, and talk about them to your doctor to note that it's still ongoing. You never didn't have sinusitis; they just took it off of your rating sheet. And then I would also see if your doctor would be willing to say, okay, I have these symptoms. What do you think is due to rhinitis? What is due to sinusitis? I guess that's a little easy. The infections are due to sinusitis, but when you have a combination of disabilities, it's kind of hard to pinpoint exactly what symptom comes from where. So I would consider what symptoms you have, because it absolutely could be worth it to go ahead and get an additional rating for the condition in addition to the rhinitis that you just have now. Okay. Isadora Vasquez again. Can I submit another secondary claim for hypertension for my tinnitus because of my insomnia? I did have my primary care at the VA note that my insomnia is related to my tinnitus. Thank you. And yeah, same answer. You can submit that. You can submit it either as a different theory of service connection, or if you weren't rated for insomnia before, they denied hypertension, point out that you are now.
Okay, this question's from HL. My recent GIRD claim was denied an increase, but the DBQ that was used by the examiner was the new criteria DBQ for GIRD. The examiner should have used the old criteria. What should I do? So not necessarily. The law has, the criteria have changed, and the new criteria is what is being applied now. So you're not going to get an increase based, you can't go back and get the old criteria applied to your condition as it goes forward. It's going to be the new ones. And don't you agree, Rachel?
Yes, I do.
Okay.
And they changed them, I believe it was May 2024, to be, they're not as favorable. The GIRD ratings specifically are definitely not as favorable as they used to be. And they are rating with that new criteria. So that is something I've been cautioning clients or anyone watching in general. If you are rated for GIRD already, you were rated before May 2024, and it's above a 10%, they're really not giving out ratings under the same criteria that they were before. Now, to get a rating that's over 10%, I believe you have to go in for, I believe it's dilation of your esophagus. You literally have to have a stricture and continued treatment to improve that stricture. Obviously, that's not the only GIRD symptoms, or, not the only symptoms, just the actual restricted esophagus. There's a lot of other things that the prior GIRD ratings accounted for, but they're not counted for now. So if you have a rating and it's 10% or higher, I would leave it alone if you can. Okay, We Jammin asks, what happens to 100% P&T rating when the rating schedules change? VA removed the 100% for my disability, and now you can only get 30% for that disability today. Will they try to reduce my 100% P&T? They know, as long as you don't file for an increase in that condition or raise that issue. If you're at 100%, like Shannon mentioned when we were talking earlier about GIRD, it's rated under like whatever criteria that applied at the time that you were granted is your rating going forward, especially if you're permanent total. It's not expected to change. But if you raise the issue for whatever reason, I don't know, you wouldn't, you're already at 100. Let's say you did, or raised it in another way, the VA could say then, okay, well, you've asked us to look at it. We're going to take a look. And then they could apply that reduced disability criteria. So they should not try to reduce it as long as you don't poke the bear, so to speak. I hear that a lot. What do you think, Shannon?
I agree. Permanent and total, it's so hard to explain it to people because it kind of means permanent and total, and then it kind of doesn't. So as long as, VA is overworked and they have too much to do. Do they have time to go back and look and try to figure out a way to reduce your rating if you're not on their radar? Not really. But if you are filing new claims or filing appeals or raising your hand and saying, look at my case, then they will, and they can. And so they can reduce even a permanent and total rating up until 20 years when they have to show fraud. But before that, they have to jump through some hoops, but they can reduce your permanent and total rating. So just always be aware of that when you think about filing something new with them. Consider that does allow them to look in your file again.
Yes. And especially here where the criteria has definitively changed, they could do that. So I would leave that alone, that issue at least.
All right, I think we have time for one more. I've got to finish up just a few minutes early today. This question's from Terrence Brown. I have a BVA appeal. I've been at the BVA since 2015, remanded 4 times. The last one has been at the RO since 2022. What do I do? Well, that's not good. Let's see. So it's been up and down several times. I'm assuming they sent it back to the RO to do something, maybe to get an exam. 3 years sounds excessive to me. I would want to make sure, first of all, that they haven't closed your case for no reason, like we were talking about earlier. That does sometimes happen. I've seen a board remand never get opened up on the regional offices. They never give it what they call an EP number. So that means nobody ever looks at it again unless you raise it for them. So my first thing that I would do is ask for a status update. Call the VA, write them a letter, whatever you need to do, email somebody, however you can contact them, and find out why your case hasn't been moved on since 2022, because that's not common. A remand from the board should be expedited. They should be treating that quickly. The fact that it's still sitting there means to me that somebody's dropped the ball somewhere. There are other alternatives. It's possible they gave you a CMP exam and then somebody looked at it and said, that's not a good CMP exam. And they sent it back and got another one, and it's taken years. And, you know, I mean, I'm not going to say there's not a series of events that could happen that would make it still sitting there, but my fear is that that's been lost.
Yes. And you can get it. When you point it out, if that does happen, they will reinstate it. You will have the claim is just as if it was never closed. So I know that always people are like, it's closed. Oh my God, my effective date's gone. No, if it was, absolutely raise it to VA, point them up, ask for a status update. And I would also look at the board remand that they sent, just so you know what's going on. Look at the last board remand, and towards the end, they're going to say, if they don't grant it or deny it, they say why it has to be remanded. Return to the regional office to request federal records or to request a CMP opinion. So I would also take a look there at the actual decision, see why they remanded, what they asked the regional office to do. And when you talk to the VA, say, you know, the board asked for a CMP exam. I went to one, you know, the beginning of 2023. What's the holdup? Or the board wanted these federal records. What's going on? Why don't I know about this? Why isn't any action being taken?
And that has been something like we were saying, there's ways that this could happen. I have seen them request records that can't be found. And what you can do to get that moving sometimes, if they're not important records, or if you know they're not getting them, you can waive that and say, you know, I waive my right to you getting those records. The problem with doing that is then you've waived it. And you can't later come back and say, well, you didn't get these records because you told them they didn't have to. So I'm always very cautious about waiving things. But if it's really something that, I mean, sometimes they ask for something that there wasn't ever a record of, you know, and you know there's not going to be a record of it. So just waive it. And that can get them moving again on that too. But like Rachel said, you need to read and find out what they remanded for, and then find out where they are in that process.
Definitely.
All right. I think that's it for us today. Thanks, Rachel. Thanks, everybody, for joining us today. And someone will be here again next week. I think it's me. So we'll be back next week to answer your questions. Thank you for your service.
Thanks.